100 words per minute for 10 minutes. 5 seconds more. Start. The petitioner, which is a construction company, is aggrieved by the issuance of a fresh tender for construction of family quarters at Siliguri by respondent number 2 when in an earlier tender for the same work the petitioner had participated and was adjudged as the lowest bidder. The petitioner therefore has prayed for passing a writ of mandamus or any other writ quashing the notice for retender issued by respondent number 2, pass a writ of mandamus or any other writ directing the respondent number 2 to award the tender to the petitioner being L1 and rates being very reasonable, and to grant any other relief which this honorable court may deem fit and proper in respect of the facts and circumstances of the present case. A notice inviting tender was issued by respondent number 2 for construction of family quarters at Siliguri. The petitioner participated by depositing earnest money in the form of FDR in the Office of Executive Engineer, New Delhi. The technical bids were opened and 11 out of 12 bidders, including the petitioner, were found to be qualified to participate in the financial bid, and the bids were to remain valid till 14/12/2016. It has been submitted on behalf of the petitioner that on the asking of respondent number 2, the petitioner extended the validity of the bid till 31/2017. The petitioner was thereafter intimated that the financial bid would be opened on 21/12/2016. The petitioner was adjudged the lowest tenderer, and his price was 12.6% lower than the estimated cost of the tender. All of a sudden, thereafter, without any reason, the petitioner received a communication through email dated 13/1/2017 that the tender in question had been recalled. The learned counsel appearing for respondent number 2, on the other hand, submitted that though the financial bids were opened, but a doubt arose as to whether all the participants were communicated about the requirement of getting their tender validity extended. In order to ascertain as to what had actually happened, we called for the relevant files and perused the same. We found that on 29/12/2016, the chief engineer sought an explanation from the executive engineer as to whether one of the participants was intimated in writing for extending the validity of its tender, to which the executive engineer had replied that there was only telephonic communication for extension of validity with their office. Hence, it was felt that equal opportunities and level playing field were not provided to all the participants. A decision was then taken for rejecting the tenders without going into the merits. the learned counsel for the respondent has submitted that only for affording a level playing field to all the participants, a decision to recall the tender was taken, which cannot be called unfair or designed to favoring any particular tenderer. The learned counsel for the respondent number 2 also raised the issue of lack of territorial jurisdiction of this court to entertain the present petition, primarily on the ground that the office of respondent number 2 is located in Gangtok. The impugned decision has been taken in Gangtok, and the work under the tender also had to be performed at Gangtok. The aforesaid argument of lack of territorial jurisdiction was countered by the petitioner by demonstrating that part of cause of action arose in Delhi. It has been submitted that the notice inviting tender was loaded on the online portal which has its office in Delhi. The petitioner accessed the website of respondent number 2 and, as per the tender condition, deposited earnest money in the form of FDR in the office of Executive Engineer, New Delhi. The deposit receipt was uploaded on the website of the tender portal of respondent number 2. The technical and financial bits were also submitted online on the website of respondent number 2. Without going into the aforesaid question, we feel that the action of the respondent number 2 recalling the tender is not unfair but is plausible and is based on the rationale of providing equal opportunity to all the participants. There is no vested right of a participant in a tender to have an agreement of award concluded in its favor. There cannot be any insistence for carrying on with the tender on the ground that a particular participant was adjudged as the lowest tenderer. All that can be demanded and be ensured to a tenderer is that he is given a fair, equal and non-discriminatory treatment in the matter of evaluation of his tender. A decision to cancel the tender process can in no way be said to be discriminatory or mala fide if reasonable grounds are provided for recalling the same. In matters of award of contracts, an employer or an agency inviting the tender is required to act reasonably and fairly at all points of time. To that extent, a tenderer can question the decision of the employer in a court of law but cannot be permitted to question the merits of the decision. The state derives its power to enter into a contract under Article 298 of the Constitution of India and has the right to decide whether to enter into a contract with a particular person or not, and whether to carry on with the tender floated, but such right is subject to the requirement of reasonableness. The only thing which is required to be seen is whether the reason accorded for either of the decisions is based on logic and the decision is not unfair. the authority inviting tenders can enter into negotiations or grant relaxation for bona fide and cogent reasons, provided such relaxation is permissible under the terms governing the tender process. To that extent, the tenderer has an enforceable right in the court which is competent to examine whether the aggrieved party has been treated unfairly or discriminated against to the detriment of public interest. Thus, we find that there is a justification for recalling of the tender. No force now remains in the petition. Consequently, it is dismissed. The application is disposed of accordingly.